Good evening, everyone. I'm Brian Frosch. I'm the Maryland Attorney General, and this is a forum put on by the Attorney General's Access to Justice Task Force, which we formed in the wake of the COVID-19 pandemic. We realized that many of our neighbors would be faced with a multitude of issues: loss of jobs, loss of income, loss of housing, mounting debt, lack of access to the civil justice system. And the task force is hosting several forums to provide answers to folks who are, and resources to folks who are facing these difficult issues. Our first forum focused on evictions. It's available on our website, marylandattorneygeneral.gov. This evening's forum will focus on consumer debt. And if you're struggling with debt, you're not alone. Before the pandemic, Americans had amassed $4.2 trillion in consumer debt, another $10 trillion in housing debt. And in the midst of this global pandemic, people are having difficulty keeping up with expenses to meet their basic needs. And I'm talking about things as simple as housing, utilities, food, medicine. The CARES Act provided some relief, but it didn't reach as far down as it should have to people who are not making a lot of money. The $600 weekly payments under the CARES Act expired in July, and it's put many consumers even further behind. The courts are reopening. We're expecting a flood of debt collection lawsuits. And we hope to answer many of the questions that people will have relating to what to do when you get a summons telling you that you're expected in court, and what to do if you go to court and don't believe you owe the debt. What happens if the court finds you owe money? I would encourage you, again, to visit our website, marylandattorneygeneral.gov. Not only will we have the videos of last week's proceedings, but also this and future ones. So I think now I'll introduce Rena Shaw. Rena is the executive director of this task force and also of Maryland's Access to Justice Commission. Rena, why don't you take it away?
Thank you so much, Attorney General Frosch. And I just want to start off by thanking the Attorney General for his leadership in bringing this task force together and bringing these kinds of events together so that we can directly interact with you all, Marylanders that may need assistance with these types of civil legal issues. I also want to thank the Maryland State Bar Association, which enables the work of our commission, and we thank them for the partnership and for their support. As Attorney General Frosch said, there are so many things that we know you all are facing. One of the key things that the Access to Justice Commission works on is making sure that when people face a civil legal problem, they have some place to go to for help. And because one of the key things that is a difference between the criminal justice system and the civil justice system. So in the civil justice system, if you face consumer debt issues, if you face housing issues, or if you face immigration issues, or if you have problems with your public benefits, in those cases, you do not have a right to an attorney if you cannot afford one. And we know that if you have legal help or if you have legal representation, it makes a huge difference. There's a lot of studies out there that show, hey, if you had an attorney to help represent you, you would have an 83% chance of winning your case. But if you don't, then you only have a 32% chance. So it makes a huge difference. But without that right to an attorney, without having that right, there's no direct funding for it. And so what we really need to work on, and what this, forum is about, is making sure that you also have quality legal information and you know where to go to get more help. So that is the purpose, and we're supporting that purpose. And there's a lot of resources that you can reach out to get help. So thank you so much for attending, and there will be time for questions at the end. We encourage you to email and write your questions in the YouTube comments as well. Now I'm going to hand it over to Ingmar Goldman, who's going to be our moderator for this event. Thank you so much.
Thank you, Attorney General Frosch, and thank you, Ms. Shaw. My name is Ingmar Goldson. I'm a private practice consumer attorney in Silver Spring, Maryland. I'm going to be your moderator today in this town hall regarding consumer debt collection and the debt collection lawsuits. Our presenters today are Jane Santoni of Santoni, Bacci, Ortega. Jane is a private practice attorney, and that office is in Towson. Our other presenter is Amy Hennon. She is an attorney with MVLS, Maryland Volunteer Lawyer Service. Now, just for a short introduction, with respect to my experience as a consumer lawyer, quite often people call me when they're being sued by a debt collector or by a bank or by another creditor. It happens a lot in Maryland and every other state, as Attorney General Frosch just mentioned a little bit earlier. But you may be able to avoid these potential lawsuits with the information that you're going to learn today in this town hall. Now, in my own experience as a consumer and as a consumer lawyer, I know how stressful that it can be when you're being pursued or even harassed by a debt collector. And a lot of that stress and apprehension comes from not knowing what to do and not knowing what could happen, not knowing the process, not knowing your rights. And that's what we're here for today, to arm you with some knowledge. And we have a lot of really good, really important information for you today. And we're going to reserve questions for the end, but please, when you think of the questions, email them to us or just type them in the YouTube chat. Today, our presenters are going to talk about not just debts, but the lawsuits that could follow debt collection and also the judgments that may come afterwards. One big point here is if you have any issues or questions relating to an issue that you have, I would encourage you to seek the help of an attorney. We do have some resources that we're going to present to you in this town hall. So now I'm going to pass the torch to Amy Hennon. Amy, please take it away.
Thank you, Ingmar. Next slide, please. So I want to start off by talking about what happens when you fall behind on your bills. Next slide, please. So if you feel yourself, you're potentially going to miss a payment, or you're just feeling overwhelmed with debt, your first step should certainly be get organized. It should be figure out who you owe and how much you owe them. But not only that, prioritize your needs, prioritize your housing, prioritize keeping your utilities on, prioritize ensuring that you and your family have healthy food to eat. And there are potential resources that you might be able to get access to. There are potential public benefits that you should take advantage of, and you can call organizations like the First Call for Help 211, and there are also consumer credit counseling agencies. I would encourage you to choose a licensed nonprofit one, including ones like CCCS of Maryland. If you are not, so when you're trying to figure out who you potentially owe money, I just want to flag that if your debt gets sold to a debt buyer, that might be somebody else on your list of creditors that would be a new name. Next slide, please. So if you are, once you've gotten organized, you've figured out who you owe and how much you owe. If you're going to get into a payment plan, you want to do that in writing. Again, this is a situation where before you start entering into these agreements, you might want to just have a consultation with somebody that can kind of help you get everything squared away. You don't want to enter into an agreement that you don't fully understand, or maybe you later find out that maybe something was not fully clear. But you want to prioritize making sure that these payments are affordable, because if you can't afford to keep them up, this payment plan is not going to be useful to you. And then, of course, you want to keep records of all of this. You want to keep proof of any payments that you make. You shouldn't trust that your debt collector is going to keep everything 100% as you expect them to, and that you, because if you have those records, then you can show that you made that payment, and they even if they don't have that record. Next slide, please. Just a few things that I want to flag about the sort of the debt collection process prior to getting into a lawsuit. If you're experiencing collection calls from some sort of debt collector, you may get these calls from collection agencies, from lawyers, from third-party debt buyers, and they can occur in a variety of different kinds of debt. You could be getting these calls. Next slide, please. But there are some really important consumer rights to know. And some examples of this include that they're not allowed to call you before 8 a.m. or after 9 p.m. They can't be abusive. They cannot tell you things that are not true. They can't say that they're gonna have you arrested. And if you are getting phone calls like this, and you think that if you think a debt collector is being abusive, it's important again to get a consultation with an attorney, because they're not allowed to do these things. Next slide, please. If a debt collector is reporting incorrect information to a credit reporting agency, or they're charging fees that they're not allowed to, again, these are additional things that I want to flag for you that should be important for you to know that debt collectors are not allowed to do. And again, it's important for you to get some information. There's also an important phone number on this slide for the Maryland Attorney General's Consumer Protection Division. You can contact them if you're having an issue with a creditor like this. I do want to just flag that if you have a creditor saying that they're going to send the sheriff out to your home, that it's too late for you to enter into an agreement, or ask them to send you proof of their collection in writing, or they're saying that you need to pay by gift card, it should be a real flag for you that this is not actually a real legitimate debt collector, but actually a scam. Next slide, please. So when you're dealing with this debt collector, and if it's a legitimate debt collector, they need to tell you who they are. If you request that written verification that I was talking about just moments ago, they're required to send that to you. If you tell them in writing that they need to stop contacting you, then they're required to do that. And they have to apply the payments in the way that you specify. Next slide, please. I'm going to turn this over now to Jane Santoni with Santoni Vartiottega.
Okay, am I unmuted? Hi, everybody. I'm Jane Santoni, and I'm happy to be here tonight. My portion of this discussion with you is what happens if you do get sued. So this is debt collection in the courts, and let's go to the next slide. So what if someone who you owe a debt to files a lawsuit? Well, the best piece of advice we can give you tonight is don't ignore it. Sometimes it's really hard because you're overwhelmed, and you've got a lot going on, especially in the middle of COVID. And so it's easy just to try to put your head in the sand like an ostrich. But that can be very, very dangerous, because if you ignore a court notice, really bad things can happen, such as you could get a judgment against you, your wages could get garnished, your bank accounts can get garnished, there could be liens on your house. So if you get an official document from the court, don't ignore it. Get advice from an attorney. Things have really improved, and I'm so grateful for the hard work that the state has done in getting these self-help centers established in all of the courthouses. There's a number listed. You see the hours are 8:30 a.m. to 8 p.m. There's also a website listed. If you get some of these court papers, call them or email them or stop in the courthouse. Okay, next slide. All right, so here's what happens when you get sued. A lawsuit is filed in the court by the person who's suing you, and then the court issues what's called a summons. That's just a piece of paper that tells you you're being sued. Okay? You are the defendant or the debtor, and the person who is suing you is called the plaintiff or the creditor. When you get that summons, and it'll either come to your house, it should come to your house in one of several ways. You'll either get it by certified mail that you would have to sign for, or someone would physically deliver it to you, or they can physically deliver it to an adult member of your household. And so again, you might want to, if there's a possibility that you think you might be sued, you want to alert everybody in your house that if something comes for you, to don't just ignore that. So when you get that summons, at the bottom of it, there's something called a notice of intention to defend. That has some blank lines for you to fill out, because if you don't fill that out, there's a possibility that a judgment could be entered against you, not automatically, but close to automatically. It's called an affidavit judgment. So you want to make sure you tell the court, hey, I want to defend this. I don't want you just to automatically enter a judgment against me. And the way you let the court know that you want to defend the case that they filed against you is to complete that form and send it back in. And again, the Self-Help Center can help you with that. Okay, next slide. So you're being sued for debt. Well, maybe you really owe it, and maybe you really owe the full amount, and maybe you don't. So let's talk about some of the reasons why you may not. Well, maybe you've made payments on that debt, and when you get the lawsuit, they say you owe more than what you actually owe. Maybe they say you owe $500, but you've made $200 worth of payments, so you only owe $300. That's a defense that you have. You can go in and you can say to the court, hey, look, here's my evidence. I've paid $200. You can't sue me for the full $300. Maybe you've already reached a payment plan with the creditor, where the creditor has agreed that they're not going to get a judgment against you as long as you make your payments. So that would be a defense to say, hey, you can't come in and sue me and get this judgment because I've made an agreement with you. You have to honor that. Maybe you didn't get the right documents. Maybe they didn't supply all the documents they need to supply you with to prove that they owe the debt. Maybe this debt's too old. If it's a debt from more than 3 or 4 years, then they probably cannot collect. And that actually happens a lot, especially when you had a Sears card and then Sears says, well, we're tired of trying to collect. We're going to sell it to this other company, and they're going to sell to that other company, and they're going to sell to that other company. By the time you get it, it's a name, like Amy said, you have no idea who's suing you. Well, it could be that that debt is too old, and the law says you have a certain time frame when you can file suit for these debts, and after that, you don't owe it. So you want to check that. Maybe you filed bankruptcy, and if you filed bankruptcy, this debt was part of the debts that were discharged. They can't come after you if it was discharged in bankruptcy. Maybe you were sued in the wrong court. You're supposed to be sued in the court where the contract was entered into or where you live. So if you received a knee replacement in Baltimore County and you live in Baltimore County, they cannot sue you in Prince George's County for your knee replacement, okay? Maybe you don't have the debt at all. Maybe you're the victim of identity theft, or maybe it's your son's debt, or maybe it's somebody with a similar name's debt, or maybe it's your spouse's debt. So maybe it's not yours at all. So those are the possible defenses you may have, which is why it's important not to ignore this, okay? If you have these defenses, though, you have to provide as much as you can in writing. The courts tend not to respect your explanations if you don't have something in writing to support it. If you made that $200 payment, show the receipts. If you discharged it in bankruptcy, bring the bankruptcy documents. It's really, really important to have those papers with you in these court actions. Okay, next slide. So you believe you have defenses. You filed your notice of intention to defend, or even if you haven't, that piece of paper at the bottom of that summons you got, okay? Regardless of whether you've done that, don't ignore the court date. Show up. In fact, it's especially now with the COVID situation, you want to show up early because they're going to ask you a series of questions. You're going to have your temperature taken. You're going to have to wear a mask. And if you really have concerns about it, you can go ahead and file for a remote hearing. There's the website, but don't ignore it. And we know it's a pain in the neck. You've got work, you've got childcare, you've got all sorts of issues, but you don't want a judgment if you can avoid it. And oftentimes, if you just show up, you can work something out, or you could tell the court about those defenses. Okay, next slide. Okay, so the trial. The person who's suing you, or the company that's suing you, has to prove that you owe them money. So they generally have to do that with documents to show that there's a debt and that you didn't pay it. A lot of times, believe it or not, they don't have the documents that they are supposed to bring. So if someone is to say to you, well, don't you just agree that you owe the debt? You're not under any obligation to answer that, at least before trial. It's their job to prove you owe the debt. Now, you can never, ever lie to the court, but remember, it's their obligation to prove it. So a lot of times debt collectors will try to put you on the spot and make you confess to something that it's their obligation to prove. For example, if they come in and they say, well, you owe this credit card debt, but they don't have the credit card statements, they may never be able to show you owe it. And if you say, well, yeah, I guess I do owe it, well, now you've just admitted something that maybe there's no way they could prove. So just be careful about that. They usually have to present documents to show that it is owed. If they do that, then you have a right to also come in and defend yourself. But again, if your defenses are, I paid some of this, I filed bankruptcy, I made a deal, bring the paperwork to do that. Because oftentimes the people who are suing you are very, very familiar with how to navigate the courts. And so they will have all their documents in a row that they need. And if you don't have something to challenge that, then judgment could be entered against you. One of the things to be very careful of, it's one of the horror stories in the 33 years I've been practicing in court. It was one of the worst I've heard, where right before the courtroom started the trials, the judge said to the people in the courtroom, we know you're busy, you have families, you have jobs. If you just file this consent judgment, you can all go home. What the judge failed to tell those people is that by agreeing to what's called a consent judgment, they were admitting that they owed the money and exposing themselves to having their wages garnished, getting liens put on their property, having their bank accounts taken, or part of their bank accounts taken. So be very, very, very careful what you agree to. And if the judge appears somewhat hostile to you, or if the defense lawyer appears somewhat hostile to you, that doesn't mean that you don't have a defense. You still have the right to go in there and challenge what they're saying about you, as long as you have legitimate challenges. You can never make anything up. You can never say anything that isn't accurate. But a lot of times, just because they say it forcefully doesn't mean you owe the debt. All right, what happens next? Say, despite all of your efforts, you get a judgment against you. Amy, take that away.
Thank you, Jane. So if you have gotten to the end of this and you have this process and you have a judgment against you, or maybe you already have a judgment against you, it is possible to look in Maryland Judiciary Case Search and see if any cases have been filed against you. There may be things out there that you don't actually even know about right now. But if you get this judgment against you, there is a narrow window for appeal. You have, if you know of the judgment, and you have 30 days after the judgment has been entered in order to file an appeal, or you have 10 days to file a motion to alter or amend, which would be just change the judgment. So this is important to think about, but let's say that you didn't even know that the judgment against you existed. It would be important to have both an underlying defense to the lawsuit, why it is that you don't owe the money, and proof that you weren't served. And so this can be challenging to do. You should get help writing if you're going to do this motion on your own. You want to get help writing one of these motions to vacate this judgment. Because if you can prove that you didn't owe the money and you weren't served, if you weren't served with the paperwork, you weren't properly provided with the paperwork the way that the process requires, then you might be able to get the judgment taken away, and you might be able to get another chance to defend the suit. But it's important to get some assistance, and it's important to keep all of your records so that you can show that you didn't owe that underlying amount. Next slide, please. So, but let's say that you do owe the money and you're not going to be able to get the judgment removed. And so you're getting to the point where the creditor is going to, the plaintiff in the case is going to try to get at your money, try to figure out where you work, try to figure out where you bank, try to figure out how to collect on that debt. They may send you what would be, now the title of this is Discovery and Aid of Enforcement. And this just means questions that they want to ask you so that they can collect your money from you. And they might send you something called interrogatories, which just means a list of questions that they want to ask you. Or they might ask you to attend an oral examination, which is where they ask you to come to court and show proof of your pay stubs, potentially show your tax documents. Now, with these interrogatories, with these list of questions that they want to send you, they may be asking more questions than they're allowed to ask you. They may be asking things that they're not necessarily entitled to get from you. And so again, it can be important to get information, some competent legal advice about what you should do, because they're not necessarily entitled to all of that. But it's really important that if you do get one of these requests, if you do get one of these interrogatories, if you do get one of these requests for an oral examination, you don't ignore it. As Jane was mentioning before about not ignoring the summons for your trial, again, you don't want to ignore one of these requests, because unfortunately, we have a process in Maryland where a few steps down the road, there could be what's called a body attachment against you for failing to follow this court order. And if you get one of these entered against you, it functions a little bit like an arrest warrant, not entirely, but like, and it could result in you getting picked up by the sheriff, or if you have an encounter with the police, you might spend an evening in jail before you have an opportunity to potentially get released, potentially get seen by the court, and it can be a really frustrating process. And so that's why it's really important not to ignore this. Next slide, please. But the good news is that there are some, if your creditor is going to try to get at some of your funds, get at some of your income, get at your bank account, there are some things that you can protect. And this is going to include a sort of $5,000 kind of catch-all for things that you need for your job. But there's also a $6,000 just anything kind of amount that you can protect. If you get a bank attachment, if your creditor files a request to seize your bank account or take the money in your bank account, you can actually file a form to exempt that money from collection up to $6,000. So that is a step that you can take as soon as you find out that you've got that freeze on your account. Again, this is something where you could go to the self-help center in order to get some assistance with this, get an attorney to represent you in this process to protect that amount of money. In addition to these exemptions that you can potentially make, there are a couple of other exemptions that could potentially be made. There are exemptions for prescription home health aids, and then $1,000 for personal or household goods, and then retirement accounts are also exempt from collection. Next slide, please. If your creditor is going to try to take your income, they can take up to 25% of your income. And that is going to be income coming generally from work. If you receive federal benefits, public benefits, your creditors cannot go after these funds. They cannot garnish these from perhaps Social Security, child support. These funds cannot be seized directly. For instance, with Social Security, if you have less than 2 months worth of your Social Security payments in your bank account, your creditor is actually not, and it's only Social Security in there, your creditor is not allowed to even touch your bank account, freeze it, anything. And you shouldn't even have to file that exemption that I was talking about before. I do want to mention that what I'm talking about here about protecting your income and your bank account from attachment from somebody taking it from you, is that this doesn't always apply if we're talking about income taxes, if we're talking about child support, or if we're talking about federal student loans. There are things that cannot be protected from those three. Next slide, please. So this bank garnishment, it puts a hold on your account. You can't access any of your funds. If you have a check or you try to pay something out of that account and it gets deposited after that freeze has hit your account, that payment is going to bounce. So if you get a freeze on your account today and then next week your car insurance was going to pull from your bank account, that payment is going to bounce, and then you're going to have a separate problem with your car insurance. So this is important to stay on top of these sorts of things. The other thing that's really important to know is that any funds that get deposited into these accounts will also be frozen. And so if you know that you're going to have a payment coming into your account, if you can redirect that payment to another account or open up another account and have that payment directed there, that can be a good way to protect yourself from more of your money being frozen. Now, if there's a judgment that's against a spouse, if there's a judgment against a spouse and the bank account is in both spouses' names, then in fact, the funds are actually considered property of the marital couple as a whole, and so they're not necessarily, the judgment isn't necessarily entitled to attach the amounts that are in the account because it's protected by this protection that specially exists for marital couples. But it is still possible there could be a mistake that gets made, or if the judgment is against both of the parties, both spouses, then that bank account could be attached. Next slide, please. Thank you. Things that are really important to know, that motion to release those funds, that $6,000 exemption that you could take that I was talking about before, that can take weeks to get your funds released. In some jurisdictions in Maryland, it can take between 4 and 6 weeks. Things that you might consider doing is calling the creditor's attorney to ask if they would consent to the funds being released. And if you can walk that motion into the clerk's office and request if you can get an order that same day, especially if you've gotten the attorney to consent. But certainly I would encourage you, again, go to one of the self-help centers or otherwise get some advice about filling out that form properly. That'll help ensure that you are going to have the best possible result. You are entitled to keep $6,000, but it may take a while before you're able to access it. Again, it's really important to if you have any new funds that are going to be going in, see if you can get those going somewhere else. Next slide, please. So let's say that you have paid the judgment finally, and now what you need to have happen is an order of satisfaction, a notice of satisfaction being filed with the court, especially if you're having your wages garnished, that 25% of your paycheck has been coming out for months or years, and you need to get it to stop because you've now paid them in full. This notice of satisfaction has to be filed. If the creditor who has the judgment against you doesn't file that, you can file a motion yourself to request that it be declared satisfied. And so again, you're going to need to have proof that all of the payments have been made, that the total amount has been covered, including any attorney's fees or interest that they've attached to it. So again, really important to keep all of your records really carefully. On the last slide, we have some really important resources, including the Self-Help Center that we've been talking about along the way, as well as Community Legal Services of Prince George's County, my organization, the Maryland Volunteer Lawyer Service, Midshore Pro Bono, which is on the Eastern Shore, and Maryland Legal Aid. And I think now we're ready to take some questions. Sorry, Ingmar, I think you're muted.
Yep, got it. Thank you so much, Jane. Thank you, Amy. And thank you for making my job so easy here as moderator. So my first question here is about identity theft. I'll shoot this question to you, Amy. Amy, what if I know I am a victim of identity theft and I told the creditor that they don't care and they just sue me anyway? What do I do?
This happens a lot. Many people are the victim of identity theft. And in fact, this is really common with debt buyers, because if the original creditor finds out that that they're not going to have an easy time collecting the judgment because you've told them that you were a victim of identity theft, they may sell it for a very small amount of money to a debt buyer who's going to then try to collect on that money. So if you know that you've been the victim of identity theft and the creditor hasn't listened to you, one really critical step can actually be obtaining a police report. This can be frustrating because you may not want to have an interaction with the police, and that's certainly understandable. There is an identity theft police report that can be filed online. In general, I don't always recommend that, simply because if there are further questions, it could result in a police officer potentially coming to your home to ask you a few more questions, and that may not be an experience that you want to have. So instead, I often recommend that people physically go to a police station, which can be difficult in its own right, so that they can file that police report and get that and get it as quickly as possible. But that police report has been sworn out under oath and is going to allow you to prove to the creditor that this wasn't you. It can be a little tricky if you know who the person was who stole your identity. You might have to swear out a complaint against that person, and there are reasons why you may or may not want to do that. But also, this will serve as proof when you want to notify the creditor or notify the court with this concrete proof that this wasn't you. In addition, if you have other proof that this wasn't you, that this wasn't your address, that you never lived at that location, that can be really valuable and helpful.
All right, thank you. This next question is to both Amy and Jane. I'll throw it up to both of you. Is there a limit on garnishment of commissions? Apparently there used to be no limit. Is there a limit now? Do either of you know that?
I'm not aware of any limit on garnishment of commissions. So, I mean, I know that you have exemptions, which Amy talked about, but I'm not aware of any limit. Amy?
No, there is no limit on commissions, even though commissions often for many workers wind up functioning as if it's their salary. It doesn't apply to that same 25% that I was talking about before. Instead, the creditor can potentially file a garnishment directly with the company that's going to be paying you that commission check, and the creditor can potentially ask to seize 100% of that commission check. So your options potentially include filing to exempt that money with that same form that I was talking about before, that $6,000 exemption. And another option might potentially involve thinking about filing for bankruptcy, and whether or not that's right for you, you're going to want to have, again, obviously competent advice. You're going to want to talk to an attorney about whether or not it's going to work for you and whether or not it's going to be appropriate for you.
All right, thank you. Shane, question about financial counseling agencies. How do you spot a legitimate one? And
Well,
what should you avoid?
So you shouldn't be paying any money up front. If any of them ask you to pay money up front, run the other way. Check the nonprofits first, although a lot of companies will call themselves nonprofit. Many of these companies will ask you, what they'll say is, first you stop paying all your bills, and then we'll combine all your bills and we'll negotiate. That's extraordinarily dangerous, because if you stop paying all your bills, then you're subject to a lawsuit. And the credit counseling agencies will often take a cut of what you would otherwise pay. So now you're in even worse shape. So my recommendation would be, before you go to any, contact the self-help center. I think Amy posted legitimate nonprofit credit counseling agency. I forget the initials you used, Amy, but again, if they're asking for money up front, or if they're telling you to stop paying your bills, very, very dangerous.
Thank you. And thank you for putting that up.
You could absolutely contact 211 for a referral, and the one we had mentioned before was CCCS MD. The other thing that I just want to flag is that that the Federal Trade Commission, the FTC, also has some important information if you are trying to recover from identity theft that we were talking about before. And it's also something that you can alert the Attorney General's office about. Again, that phone number that was earlier in the presentation, it's the Attorney General's office has a real wealth of resources that are available. And so I would encourage you to make use of them.
And the other thing that I would suggest too, before you pay anybody, do your homework. The internet can really be helpful if there's the name of a debt collector or credit counseling agency or even a lawyer. Look them up, do a little digging. And if you start to see a pattern of, this person is really scummy, or this is what they did to me, if you start seeing things like that over and over again, that will be helpful for you to determine how legitimate their claims against you or to help you might be.
All right, thank you. And Jane, because you just brought up the internet, I'm going to direct this next question to you. I read on my friend's Facebook post that I'm not liable if the bank can't produce the original contract with my ink signature. Is that true?
No.
All right, that was a quick one.
A copy could be sufficient. And sometimes if they can have somebody who is the custodian of records come in, they can even testify to things, to documents they may not even have if it's a regular course of business. So do not assume that just because they don't have a document that you're out of the woods.
All right, thank you. And this one is for Amy. What if they just start garnishing my wages on my bank account and I never even saw notice of a lawsuit? How is that fair, and what am I supposed to do about that?
Oh, I hate that. I feel like I see that all the time. And it's so frustrating because you're already losing money. And so a couple of questions come up immediately is do you owe the underlying debt? Because again, what I was talking about before, if you've already got the wage garnishment, it means that it's been more than 30 days since a judgment has been entered against you. And so If you don't actually owe the underlying debt, if you get a little more information about the lawsuit and it's not actually yours, then you have a valid defense. You have a legal defense. You should get some help fighting this, because you can file a motion to vacate the judgment and explain that this is not your debt, or that this debt was already paid, or something, that whatever your defense is. If you do owe the debt, if this is your debt and you have just discovered that you are being garnished, this is a really frustrating situation. It might be possible to potentially contact your creditor and ask if they would voluntarily reduce the total amount based on a hardship. If you can demonstrate that you're gonna with whatever's going on, that you're gonna lose your housing, or that you're not going to be able to provide any food at all to your family. This is something that you could ask. They're not necessarily required to grant it, and so it's a really frustrating situation.
Yeah, and I'd like to add on to that regardless, if you owe the debt, but the first, I guess your first introduction to this lawsuit is them taking money out of your bank account, then seek legal counsel immediately. That is not okay. It's never okay. That means that they never properly served you, and you really need to hire an attorney to help figure out the best way to address that issue. There are several different things that could happen, different ways to approach that depending on what's going on with your particular case. But main point here is that it's not okay. Make sure that you contact an attorney. But one other question for you real quick, Amy. What if I'm being sued for, I'm being sued on an account where I never really borrowed the money. I was just a co-signer.
Another really super frustrating situation.
Sorry, I'm giving you all these frustrations.
No, it's really important. I often talk to people who have co-signed on a debt for somebody. They are thinking, I'm just signing saying that I agree that I believe this person is going to pay this debt. But what they in fact have done is made themselves 100% liable if that other person doesn't pay. And if you're the co-signer, you might not get notices telling you that this person, that the first in line borrower, the first in line, and it could even be a tenant in a rental in an apartment, that you might not get notice that they stopped paying their car loan, that they stopped paying for their apartment, they stopped paying their rent, and then maybe the first time that you even hear about this is that when you have a lawsuit filed against you, and this is really, really frustrating, because even though the other person hasn't paid, if they find you first, they can get 100% of that money from you. Because you co-signed saying that you were going to be liable, and those contracts always say that it's this concept of joint and several liability, meaning that the debt is to both of you, but also to either of you, whichever one they find. And so the only way to avoid ever having to be fully responsible for somebody else's debt is never co-signing anything for anybody. Let me just encourage you not to do that.
Sounds like some good advice. Now, I have a question for you, Jane. I got something in the mail called a confessed judgment, and they didn't even give me an opportunity to defend myself. Is that okay? What do I do about that?
Well, it depends. Generally, that means that some time ago you signed something that said if you didn't pay this bill, that they could automatically get a judgment against you without having to jump through most of the hoops. So you need to consider what you may have signed. If it was for a consumer good, like a car that you drive or a credit card or something like that, the fact that they tried to get a confessed judgment against you may be illegal in and of itself. So, because they can't use those clauses in consumer contracts. So chances are it may be illegal for them to even try to do that. Even if it is legal, you still have a very little bit of time to defend it. So don't ignore it. Again, go to the self-help center and get help.
All right, and just finally, I'll say, as a consumer lawyer, a couple of my favorite consumer-friendly laws are the FDCPA, or Fair Debt Collection Practices Act, and MCDCA, which is this Maryland's corollary law, the Maryland Consumer Debt Collection Act. Jane, you're a private attorney. I'm sure that you use these laws a lot in your pleadings and practice as well. Can you tell me about those?
Well, sure. Congress years ago, the US Congress, and also the state of Maryland, along with many other states, recognized how devastating it is to the average person when debt collectors come after them. And that doesn't mean that they can't legitimately come after you. Of course they can. But if they abuse the system, if they come after you for debts that are too old, for debts that you don't owe, if they tell you that they're going to arrest you if you don't pay it, if they call you 100 times a day, if they call your mother and say you should owe this debt, there are lots of different ways that they can act illegally. There are laws in place to say that's not okay, and you can fight back. And so in other words, instead of just defending the debt, you have rights where you can actually bring a claim against the debt collector who's acting illegally. They're powerful laws. They contain statutory damages sometimes, which means you may automatically be entitled to some money for the fact that the debt collector did this improperly. You can get emotional damages for what the debt collector may have done to you illegally. And they also allow for attorney's fees for acting illegally. So the legislators, both in the state and the country, have recognized that this is really serious, and they have put protections in place for you. So keep that in mind.
All right. Thank you for that, Jane. I think that does it for us today. So thanks, Jane. Thank you, Amy. Thanks, Attorney General Frosch and Rena. If you still have questions, go to the Attorney General's website. Look at the MSBA's posting of this video on YouTube and see that we did list a few resources there for you. If you have a case, if you're being pursued by a debt collector, you think you may be harassed, or if you're being sued by a debt collector, contact an attorney. Thank you.
Okay, you are now clear. You're no longer streaming.